Welcome in, ladies and gentlemen. We have a NASCAR video today. The antitrust trial is officially underway. The NASCAR trial of the century. So, what happened on day one? Matt Weaver of motorsport.com has a very detailed article about what all happened and on motorsport.com. Matt Weaver. Let's dive on in. So, before we dive on, man, make sure to like the video, subscribe to the channel, and hit the notification bell so you don't miss any football of the college kind. I'll be doing some NFL later. I don't know. We'll see. And NASCAR and Formula One. We cover all the fun things around here. So, this may not be fun, but it's very important that we keep track of what is going on. So, without further ado, article, as I said, from Matt Weaver. The 2311 Racing and Front Row Motorsport v. NASCAR Antitrust Lawsuit trial began in earnest on Monday and included jury selection, opening statements by both parties, and the partial testimony of the first witness, Denny Hamlin. Between the testimony of the co-owner of 2311, which was conducted by Jennifer Parsigian, a partner at Winston and Strawn, the opening statement delivered by lead attorney Jeffrey Kessler, the strategy for the plaintiffs came into focus. 2311 FRM argument. Kessler said that the jury will be shown evidence of an anti-competitive strategy orchestrated by NASCAR CEO Jim France over the next 2 weeks. That evidence, he argued, will come in the form of emails, text messages from the lieutenant executives Steve Phelps, Steve O'Donnell, and Scott Prime, illustrating an awareness of unfairness towards teams while negotiating charter extensions. An example of this was released over the summer in the form of a text message exchange where Phelps said the offer gave the teams 0 wins and that O'Donnell characterized it as F the teams. Offer that would take NASCAR back to its tiny southern roots, the tiny sport of 1996. Oh, 1996, you say? Oh, when the TV ratings were better? Is that it? When NASCAR was more in pop culture than it is today? Instead, it's a running joke because of fools like Jim France, like Steve Phelps, like Steve O'Donnell. What do you mean tiny sport in 1996? Uh, you can see right here on YouTube. You can go Bristol Night Race 1996. You know what's going to show? A full packed house crowd. You look at Bristol Night Race 2025, 2024, 2023. It is damn near empty. And I can promise you, because I was there, you look at the Brickyard race in 2000, I think it was 2018, maybe 17. It was the last year they were on the oval before they went to the road course. The one that Casey Kane won. I think it was 2017. It might have been 28. It might have been 2018. Oh gosh, but nonetheless, uh, I went to that race, that Brickyard race, and I went with my grandfather. We had the whole section to ourselves. It was empty. So, yeah, I don't know what you mean by the tiny Southern roots sport of 1996. Anyway, the below is a loose paraphrase in the absence of recorded audio. The other three executives all knew that NASCAR operates under Jim France, and the family is the board of directors, and the board is NASCAR. So the board is Jim France, but three executives reporting to him knew that Jim was doing to the teams, Kessler argued. The lead attorney added that NASCAR ultimately took that deal. One of his lieutenants argued that it was a bad deal and ultimately resulted in what has been characterized by several teams as a take it or leave it off final offer in September of 2024. Sign it at midnight or lose your charters, Kessler said, making his point. That is monopoly power. This is monopoly injury. And I have heard, I have heard, I don't remember where, but I remember hearing it because I was just stunned by it. That, and I think it was Richard Childress, and that may have been the whole thing of, I think it was Steve Phelps or Steve O'Donnell, saying that he should be taken out back and flogged. Uh, and I think that's where that kind of devolved from. Because I do remember Childress saying like he was kind of forced into signing it because of he didn't want to lose the charters because they're worth 30, 40 million. At the time, at least 25 million. But I mean, it's correct. That is stuff that I have heard. Kessler said the teams wanted permanent charters and didn't get them. Kessler said the teams wanted $20 million per car and got 12.5 million. He also said that the teams asked for veto power on competition changes, which were not only refused but also lost the three strikes provision in the previous charter agreement that gave the teams a degree of veto ability. Regarding charter permanency, Kessler likened the concept of buying a house versus renting a house in that the leased home can be taken away at the end of of the contract. Kessler said the teams want to permanently own their figurative house so they could extract more enterprise value from it. So, uh, we're gonna get a little bit into the weeds here. The charters, yeah, they're, they are like if you want to go real technical on it, the teams rent them from NASCAR, but NASCAR has full right to take them away for any reason. And that team is out, however much they paid for the charter. So, yeah, it is. If if 2311 and Front Row Motorsports get what they want, then NASCAR wouldn't own the charters. But at the same time, NASCAR has got to be able to be able to protect itself with these charters, and in case you do have a bunch of teams that just a bunch of charters that are just there to collect the prize money, not really run well. Who cares? They're there to turn a profit. They're not there to actually compete. So there is, I do get both sides. Um, I do get both sides of that. So I, I I'm just gonna lay out both sides. There's not really an opinion to give there. Like I understand both sides. Further doing so, would would cost NASCAR absolutely nothing, but the sanctioning body has not conceded that position. And explaining to the jury what a monopoly is, Kessler likened it to any one of them wanting to practice as a nurse. If there was only one hospital and you wanted to be a nurse, you either take whatever they pay you, or you're not going to be a nurse, Kessler said. Kessler said that there were three overreaching points to prove the argument. NASCAR tied up all the tracks with provisions that did not allow them to schedule competitor divisions without approval from the sanctioning body. NASCAR restricted teams that if you race in the Cup Series, you can't race in a competitor division without approval from the sanctioning body. That seems awfully anti capitalist. NASCAR implemented single source supplied next gen car and protected its intellectual property from being used by teams outside of NASCAR without permission, while also controlling the cost through the purchase of those parts. Yeah, that is one of the things I had an issue with this new car is the single source suppliers. So pretty much so uh to kind of simple it down a little bit, those who may not know. Um imagine imagine you want to bake a cake. You need flour, you need eggs, and you you can only get this certain you're only allowed to get this certain brand of flour for the cake. You can only get you can only get brand X. Now, there's brand A, there's brand B, but you are only allowed by the rules to use brand X. And even though brand A may be cheaper, maybe even better, doesn't matter. It's outside the rules. So that is that is in my opinion that's not what NASCAR is supposed to be built off of. That's not NASCAR. NASCAR is supposed to be a place where engineers can come together and build the fastest car within a set parameter, and that is essentially stock car is within the realm of stock cars that can be sold on showroom floors, except made much safer because of the racing conditions. You know what I mean. As close to stock as they can feasibly get. But that is uh, that is what the single source supplier is. In wrapping up his opening statements, Kessler went back to the conviction that Jim France used NASCAR's monopoly status to depress the earnings of teams competing in the Cup Series. He said that they have expert testimony that shows teams would get 45% of NASCAR's value in a fair market, and that the likes of Phelps and O'Donnell and Prime knew it. What is the evidence that is going to show that France ran this for his family at the expense of the teams? Kessler also made numerical arguments over financials. He said a NASCAR evaluation from Goldman Sachs had the sanctioning body worth $5 billion. And he pointed out that NASCAR made $400 million over the past 3 years. These were just context around the narrative about the plight of the teams overall. So that is 2311's argument that they are a monopoly and they are too powerful. They and they are and because of this monopoly that is absolutely illegal by law. that they need to have power taken away and put into the teams and allow the teams a lot more freedom. And quite frankly, if you cannot go out and be a part of another racing series especially under that same name, that is a massive, massive problem. NASCAR doesn't own that trademark. They do not own the Hendrick Motorsport trademark. They cannot be doing that. Rick Hendrick, should he choose to want to, he should be able to go out and run a team under that same banner in other series. If I'm understanding that correctly. I am by no means a lawyer or a law major, but that's kind of what I'm getting from this. So let's get to NASCAR's argument. NASCAR attorney John E. Stevenson provided the opening statement for the sanctioning body with the trial attorney making his first appearance in court for this case with Chris Yates front and center over the past 15 months. Stevenson's argument was consistent with what NASCAR has articulated over the summer. He framed 2311 and Front Row as effectively attacking the charter system, one that NASCAR has honored with every word and every cent as agreed upon each time since 2016. He frequently alluded to 2311 and Front Row as having not made any antitrust claims about the charter system until after the extension deadline, when they issued the final offer in September of 2024. Literally, none of these things were raised to NASCAR until the lawsuit was filed, Stevenson said. From 2016 to 2014, none of it was brought up. Stevenson pointed to a letter from 2311 on September 6th that explained why they were not signing the agreement, and that it made no sense from an anti-competitive behavior, and it made no mention of anti-competitive behavior. And he said the same of communications with Front Row. Instead, the NASCAR position is that 2311 likely always intended to bring the lawsuit if they could not secure the financial terms it sought from the sanctioning body. A lawsuit is our greatest leverage, Stevens said of a Curtis Polk 2311 co-owner email produced in Discovery. He also used a frequent NASCAR talking point that 2311 and Front Row continue to engage in negotiation through litigation. That is what NASCAR says 2311 and Front Row are doing, suing the sanctioning body only in the pursuit of better terms and not some altruistic pursuit of rightening an antitrust wrong. I don't know the legality of that. I mean, from everything that I've been hearing, there hasn't been too much negotiation. Obviously, leading those negotiations for the teams is going to be Rick Hendrick, Roger Penske, and Joe Gibbs. Those are the three big ones. And everybody else just has to fall in line. And that, love it or not, that's the reality. 2311 and Front Row, they are second fiddle teams. They're not at the forefront when it comes to actually negotiating. And NASCAR, they really don't need to bend the knee, so to speak, to 2311, to Front Row, because they are not one of the blue blood teams. If it was Joe Gibbs, if it was Rick Hendrick, if it was Roger Penske, this would be a whole different story, but it's not. It's Front Row and it's 2311. Uh, Teams that, quite frankly, NASCAR can survive without. Love it or hate it, that is the reality. Moving back to the article, Stevenson pointed to another Polk email that said of a proposed meeting with NASCAR that I hope they don't come because it would build our record, with the lawyer arguing that 2311 wasn't negotiating in good faith. Uh, Trying to argue about negotiating in faith is very, very tough. Um, that I hope they don't come because it would build our record. That's not so much of not negotiating good faith. That is, please make this easier on us. Uh, from everything that I've seen, like this was the plan for 2311 and Front Row from the get go, or at least from 2311. I think Front Row is just sitting Front Row, oddly enough. But I mean, I don't know exactly what kind of leverage 2311 and Front Row truly have in this. They weren't going to be able to get NASCAR to do anything in negotiations, and this was the only logical result outside of some sort of settlement, which is still a possibility throughout this trial. But both sides are dug in, and I don't see I don't see a resolution in sight that involves a settlement. He said that the private Polk emails from 2023 that expressed admiration for the France family's business acumen and made no reference to anti competitive behavior. The NASCAR position continues to be that it was made by Stevenson to the jury for the first time that if the charters were such a byproduct of anti competitive behavior and a bad deal, then why did 2311 keep buying them? Uh, that's a weak argument. You do what you have to do. Uh, Weak argument. It's a part of the rules. It's how you make money, or at least break even. You have to have a charter. You want to expand. It's just the reality of the situation. In responding to 2311 and Front Row's opening statement about the non compete clause that teams have to agree to in order to compete in the Cup, Stevenson said that it was no different than the non compete clauses that drivers sign with teams. As the provision for the teams to not compete against NASCAR, Stevenson said that the trade off, that was a trade off. The sanctioning body wanted the teams in exchange for greater guaranteed revenue. Oh my goodness, NASCAR is so it like these people do not know how to market at all. Like, oh my god, it is horrible. They are so bad at this. They are so bad at marketing. It's not even funny. Like, don't you think it would help the brand if you saw if you saw Hendrick Motorsports competing in in IMSA or WEC? Don't you think it would help? Uh, it would help NASCAR's branding to have a premier team competing in IndyCar and doing very well, a la Team Penske. Which Penske, they can get away with it because again, they are one of the premier teams in NASCAR. And also, in this particular case, they are grandfathered in. So that Team Penske owns the IndyCar series on top of all that. But nonetheless, be all in and be all in on NASCAR stock car racing is what that says, Steven argued. You're getting guaranteed money. They agreed to it. They never made claims against it until filing their lawsuit. About 2311 and Front Row's claim that NASCAR's merger with sister company, International Speedway Corporation, aka ISC, was an anti competitive measure to secure tracks and maintain their monopoly, Stevenson said. It was about the schedule flexibility and innovation because NASCAR needed to take risks for events like downtown Chicago and downtown Los Angeles despite owning nearby racetracks. Making those decisions or decisions that resulted in a loss were things NASCAR or ISC couldn't do as a publicly traded company or a publicly traded entity. Stevenson repeatedly asked, "Why are we here?" and pointed to Polk as having a premeditated plan to bring NASCAR to trial if unable to secure the charter terms 2311 and Front Row sought. I mean, there is it is not a secret that NASCAR is trying to hoard a bunch of the tracks. That is why they engulfed ISC. People were begging that Penske was the one that got the I think it was Penske or anybody other than ISC to get one of the road courses that Indy runs at. I think was it I don't remember which one it was. But there was a road course that was up for sale that people were absolutely terrified that NASCAR was going to buy and was going to prevent IndyCar from running there. So, yeah, that is anti-competitive. That is monopolized, especially because I think it's a track that NASCAR just simply doesn't go to. On top of all of that, and it wouldn't make sense for them to go to either. But anyway, now we go on to the Denny Hamlin testimony. Owner of 2311, driver of the number 11. Let's see what he said. The day ended with 40 minutes of testimony from Hamlin. These were friendly questions from his own legal team and will be cross-examined at some point early on Tuesday morning once Parsegian concludes her questions. The day began with Judge Kenneth D. Bell ruling on NASCAR's motion that sought to have only one of the three 2311 owners in the courtroom to hear all testimony. Bell was reluctant to grant the motion, but not wanting to risk a retrial on technical grounds, he ruled in NASCAR's favor. That meant 2311 had to designate the sole representative, which was Jordan, but since Hamlin is the first witness, he will be able to sit on the bench for the rest of the trial once he's done. So Michael Jordan is the representative. Oh, we're going to see Michael Jordan on the stand. Interesting. Didn't have that one on my 2025 bingo card. Anyway, Polk can join them upon concluding his time on the stand, whenever that comes. Parsegian opened the line of questioning with the basics. Parsegian, did you graduate? Hamlin gave me a diploma. How did your most recent season go? Can I plead the fifth? Or, oh, no, I got a sound effect for that. Hold on. Oh, wait, hold on. That was not. I thought it was after. Never mind. Whoops. Whoopsie. I don't think anyone is prosecuting you. I was leading the championship race with 3 to go, and the caution came out, and I lost. There seems to be a strategy to bring up the teams frequently compete with the NASCAR for sponsorships because Hamlin brought it up 3 times under questioning from his own attorney. For example, what allowed 2311 purchase Germain Racing Team Charter in 2021. They lost their primary sponsorship, Geico, to NASCAR and went out of business. What are Hamlin's responsibilities at 2311 as co-owner? It's competition and sponsorship, calling himself a professional fundraiser, but again brought up this means frequently competing with NASCAR. Why did 2311 spend $35 million to build a state-of-the-art airspeed race shop? Hamlin said it was to put their best foot forward to secure additional sponsorship and hire the best employees on the market. But again, he said he has to compete with NASCAR when a potential sponsor expresses interest in joining the sport. First, I have to fend off the series, Hamlin said. If a new sponsor wants to come in, NASCAR will go after them. I have to fight them. I have to fight other teams for them. I have to fight them for employees. Hamlin also got emotional when asked how he got started in racing and made it to NASCAR. He brought up the contributions from his parents, especially his dad, who is now publicly known to be in fading health. He said the cost to field a cup car just to get it on the track is $20 million, and that the current charter agreement covers $12.5 million of that. The rest needs to be covered by sponsorship, which Hamlin concedes that Jordan, as a co-owner, is why the team can turn profits where other teams cannot. It's what made Jordan appealing as a potential co-owner for the team. He always wanted to own his own in his post-driving days. Parsegian asked Hamlin if he felt the charter agreement is fair, and he brought up that the 11 and the 19 that 11 of the original 19 charters from 2016 have closed. So I do want to kind of circle back here. That it costs $20 million to get the car to the track. The charter agreement covers 12.5. Now, one of the things I've been saying on this channel about how NASCAR can really help itself is that you make it easier on sponsors to be able to sponsor a car for 36 races. NASCAR can cover that $20 million to get cars to the track. And if you're put in a position to where teams can get one sponsor to cover 36 races, that's going to help the branding. That's going to, and in turn, make more money. It's jumping over $1 to get a nickel. Because, again, and I bring this up every single time I talk about this. When you think of Dale Jr., you think of that red 8 Bud car. It is red, it is 8, and there is Budweiser, and there is Bud right on the hood. And it was like that for years upon years upon years, and they have such a tremendous relationship. It is iconic with one another. Jimmy Johnson with Lowe's. Denny Hamlin with FedEx. You want to go back further? Dale Earnhardt with Goodwrench, that black car. Rusty Wallace with the Miller Lite, the Blue Deuce. Terry Labonte, Kellogg's. I mean, the list goes on and on and on. NASCAR trying to save $7.5 million is chump change compared to what they actually make. I mean, you have to be able. This is so short-sighted by NASCAR, and I'm not surprised by it because NASCAR is not very good at this. That if you are able to put teams into position to be able to have one sponsor throughout the entire season and between the brand and the driver to build that relationship and become synonymous with one another, that is huge. That is how you create stars. That is how that is how you're able to market better, so on and so forth. And it's a snowball of positivity that comes when you're able to get one, maybe two sponsors throughout the entire racing season. I mean, for God's sake, it's branding 101. Stay consistent, stay identical, stay the same. Consistency is key. Of course, NASCAR doesn't know that because Steve Phelps, Steve O'Donnell, and everybody else running NASCAR has no idea what they're doing. But anyway, well, hopping back into the article, if teams were fair, they wouldn't have gone out of business. Hamlin said, only one side is going out of business. Hamlin said 2311 profits frequently fluctuated for reasons NASCAR controls, like mid-season rule updates which can sometimes cost $1.5 million per car in international races like the one held in Mexico City this past season. Anecdotally, Hamlin also revealed that 2311 Racing pays Joe Gibbs Racing $2.66 million per car a season for an alliance fee, since JGR is the primary Toyota organization. He asked why his team was just 140 employees compared to the 500 of a team like JGR. Hamlin also said that his business partners asked him to run the 2311 as lean as possible. It was at this point, the clock struck 5 p.m., and Judge Bell indicated that he wanted to end each day around this time and no later than 5:15 p.m., with each day starting at 9 a.m. Jury selection and witness list. So this day opened with a jury selection, revelation, and the revelation of potential witnesses on each side as well. So for NASCAR, it would be Jim France, CEO and presidential moron, Lisa France Kennedy, Ben Kennedy, Brian Herbst, Steve O'Donnell, Steve Phelps, Scott Prime, Tim Clark, Greg Motto, John Props, and Ron Drager. Teams: Richard Childress, Rick Hendrick, Roger Penske, Heather Gibbs, Cal Wells, the third Steve Newark, Rob Kaufman, and Jonathan Marshall. It took a little over 2 hours to get the 6-man, 3-woman jury. Bell, Kessler, and Stevenson each took time with the prospective jurors before landing on the final 9. One juror candidate was dismissed for working at Hendrick Automotive Group, and another was dismissed for knowing a great deal about NASCAR and the parties involved. They were all asked, amongst other questions, if they were familiar with Michael Jordan, if they had a strong opinions about one way or the other. One candidate said yes. Judge Bell asked, so you have a feeling that you don't tell me what they are about Michael Jordan that would prevent you from being fair or impartial? Candidate said yes. Candidate was dismissed, and on his way out the door, made a fist pump gesture at the legendary sportsman, and they shared a laugh. The illicit laughter from the entire courtroom, and Judge Bell said he appreciated the honesty. Another prospective juror had a smile exchange. Crap. Okay. So, n- there was, so going through this, there's a couple things that I do find interesting, and that it kind of gets lost. And that is, not only are teams competing with each other for sponsorships, they are competing with NASCAR as well. And NASCAR is holding all the cards. I mean, I get that NASCAR needs sponsorships too. I don't know the resolution to this, but to say it's on a fair and even playing field is utterly asinine. Um, I mean, we are having teams going out of business. Front Row Motorsports, they went out of business. And they were a championship contender year over year. So to say that it's fair is utterly false, and to say that it's anti-competitive is absolutely legit. There is some anti-competitive components to NASCAR. So that is day one in the books for NASCAR and the antitrust trial. Looks like we will get Michael Jordan up on the stand. That will be interesting testimony if you know Michael Jordan at all or know of him. He does not pull his punches. So, and he is also a showman. So we'll see what Michael Jordan has to say when he does finally take the stand. See what happens. But all right, that's all I got for you here. Make sure to like the video, subscribe to the channel, hit the notification bell so you don't miss anything, and we'll see you in the next one.